Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be discussing basics of the right to know law. A couple preliminaries before we get started with the actual presentation. First, you should know that this session is being recorded, and within a few days, a link will be posted on our website that will take you to our YouTube channel where if you want to go back and review it, or if you have a colleague maybe who wasn't able to attend this morning, you can access it off of our webpage. Also, if you've never attended one of these webinars before, it's basically a PowerPoint presentation with me narrating in the background. All of the PowerPoint presentations that we use for our webinars and other trainings as well, you can also find those on our website at the training tab. Just go ahead and scroll down and you'll find the appropriate PowerPoint, and you can use that to either follow along or, like I said earlier, with the recordings, you can use them for reference for your own needs, or if you have a colleague who wasn't able to attend, or if you're conducting local training, whatever. They're public records, so you can access them and use them as you see fit. Finally, if you have questions today, feel free to type into the chat feature as we're going through, and I'll do my best to answer them live. I have two conditions, though, that I'd ask for your indulgence with here. First is, we're talking about the right to know law, so let's stay on topic. And secondly is that if you can keep your questions as succinct as possible, as brief, that would be very helpful because honestly, sometimes folks will type in several paragraphs and it just becomes very awkward for me to sit here and have to read through it while other people are patiently waiting. If it looks like you do have a question that's either unusually complex or, very specific to your situation, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it and we can address it for the good of the order with everyone. Or we'll take the conversation offline. If you look at your screen right now, there's the phone number for the office as well as the URL for the website. That website has email links where you can type in your questions. They come into the administrative staff who are very well versed on the law, and they'll more than likely get you steered in the right direction. But if you happen to stump them, then we'll escalate your question to one of the senior staff, and they'll get back to you. As a matter of practice, we do our best to get back to you within 24 hours because we figure if you're contacting us, it's something important and it's probably time sensitive. So I would invite you, number one, take a look at our website for the resources that are available there. Number two, if you do have questions, reach out to us and we'll try and help you as best we can. We can't answer requests for you. We can't predict how agencies are going to respond to requests. We can't provide legal advice. We can't talk about active appeals, but there's so much more that we can talk about and hopefully, like I said, get you steered in the right direction. Okay, so I think that takes care of all the preliminaries. Let's dive into the subject, basics of the right to know law. Okay, why is the right to know law important? Well, it has to do with, public access to government records, transparency, which is a word we hear more and more nowadays in referring to government, and in general, just good government. The public has a right to know what their elected officials are up to. And the right to know law is an important tool in Pennsylvania that allows that to happen. But I think it's important that we focus on a fundamental statement when it comes to the right to know law. And that's the fact that the purpose of the law is to give the public access to public records. A lot of times, if you happen to be an agency open records officer or right to know officer, and those two phrases are used interchangeably, occasionally you will encounter a situation where it may not be clear as to what your next steps are, what you need to do. Not everything is presented to us in a black and white fashion. What I recommend oftentimes is come back to this fundamental statement. Okay, I've received a right to know request. What is my responsibility? Well, it's to provide the public access to public records. Okay, and no more. a lot of times people will see that term right to know, and they interpret it as some form of Google for state and local government, where they'll type in a bunch of questions or whatever and believe that government is obligated to provide answers. Pardon me. And that's just not the case, okay? Your job under the right to know law is to provide access to public records. Now, two caveats here. First off, and your starting point is that every record in the possession of an agency is presumed to be public. That's your starting point. And if you receive a right to know request that, let's just say, a red flag goes up, I'm not sure this should be made public. Well, the agency bears the legal burden of proving that a record is not public. Okay, so that's an important point. Number one, your starting point is that every record is presumed to be public unless you can make a legal and factual case as to why that record should not be released into the public domain. Okay, question has popped up here from Detective Robinson. Is the records officer the same as a legal custodian of record? No, no. And we'll talk about this shortly, but the role of the open records officer is to receive, process, and respond to right to know requests. The records may very well be under the purview of a legal custodian or several legal custodians. It just depends on the nature of the record. Some records do not require any kind of legal custodian, but very good question. The answer for the most part is no. That's not to say that there may be some instances where records are held under the purview of a legal custodian. It just depends. Another question popped up here. Can a resident ask what a municipal lawyer has charged the municipality for? Okay, another very good question. And again, the answer is it depends. When we get to the end of the or closer to the end of the presentation, we're going to be talking about something called attorney-client privilege. Invoices always come up. The answer in general is yes. Okay, an invoice is a financial record which is accessible under the right to know law, except you need to take a look at that invoice to see how detailed it is and whether or not you can discern any sort of legal strategy or guidance that the attorney is providing their client through the detail in the invoice, okay? If it's simply an attorney, charging X number of billable hours for a particular time period, chances are that's accessible under the right to know law. If the attorney is going into such detail that you can discern legal strategy, it's possible that it can be held with the municipality claiming it falls under attorney-client privilege. It's also possible that they could redact that detail so that you would be able to see simply the financial data that's included in the invoice without seeing the actual entries that would divulge legal strategy. Again, it's very fact specific. It's going to depend on the details included in the invoice, but in general, the answer is yes. Okay, very good questions. Y'all are getting ahead of me. You must have had a lot of coffee this morning. But I think we've covered the slide currently up fairly well, so let's move on. Okay, yeah, another important point here that I want to make is the fact that the right to know law is not a confidentiality law. Okay, what does that mean? Well, first off, Ann, there's nothing in the right to know law that prevents a municipality from simply giving out records outside of the right to know law. An example, let's say it's budget season and I would like, as a citizen, I would like a copy of the budget. And I go walking into the township office and there's a stack of budgets sitting there, and I ask the person, may I have a copy of the budget? Okay, there's absolutely nothing in the right to know law that says I must submit a right to know request in order to get that budget. Now, the township can do that. They can say, in order to get a copy of the budget, you have to give me a right to know request. But they can also say, here's a copy of the budget. I'll just give it to you. Okay, there's nothing in the right to know law that prevents that. Additionally, let's say I have a right to know request asking for a copy of the budget. The open records officer can actually say to me, you know what, George, if you tear that up, I'll just hand you a copy of the budget. That'll save you a lot of time and it'll save me a lot of paperwork. The agency can do that at their discretion if they want to. But if I say, no, I want to follow the right to know process, then they have to do that. Okay, but why would I do that if they're willing to give me a record? And what we recommend is that, most municipalities nowadays have websites. Well, what you should do is take a look at your right to know requests, identify the trends, that what are people asking for? And typically, like what's listed on the slide there, budgets, contracts, salaries, purchasing documents, and a whole host of other records. Okay, well, if you notice a trend, be proactive and put these records on your website. They're obviously at face value public records. Okay, people are asking for them. Okay, you're getting right to know requests for these records. If you put them on your website, number one, people are going to be much more comfortable and active sitting in the comfort of their family room on their home computers, surfing your websites to get the records that they want to see. Furthermore, while the hits on your website start going up, you'll notice the right to know requests start going down because there's no longer a need for as many of them because the public records are clearly accessible on your website, okay? Makes your life easier as an open records officer. And if you should happen to receive a right to know request for one of those records that's already on your website, your response to that right to know request is that record is on our website. Here's the link to it. And that's a perfectly valid response as dictated by the right to know law. You'll find those provisions in there. Okay, so that's what we recommend. But the big point is that right to know law is not a confidentiality law. It allows you to give out records at your discretion with no limits that are built into the right to know law itself. Okay, let's talk about the agency obligations, whether it be a city, borough, township, school district, charter school, authority, any agency that falls under the jurisdiction of the right to know law. These are the things they need to do. First, and probably most importantly, is they must appoint someone as an agency open records officer or right to know officer. Again, two terms are interchangeable. This is the person responsible for receiving, processing, and responding to right to know requests. There's no requirement that they be at a certain level within the organization. It could be, a clerk. It could be a school district superintendent. It could be the mayor. It could be the president of council. Just any person within the organization. They don't have to be sworn in. They don't have to be voted on. Here at the Office of Open Records, we consider it to be basically another work assignment, okay? There's no limit as to the number of agency open records officers you can have. It's not unusual to go to one borough and they have one person covering, everything. You could go 3 miles down the road to the next borough, and maybe they have one person covering the administrative side of operations and a second agency open records officer covering the police department, okay, exclusively the police department. You just have to look at it from the public's point of view. They have a right to know request, and they need to know, who do I give this to? As long as that's clear and the process is as seamless as possible, you should be fine. You can come up with your own rules and regulations for governing your open records program. The right to know law affords you a fair degree of discretion in how you do that. Quick example. Within the right to know law, there's a provision that says you can or you may accept right to know requests from or anonymously. Okay. Well, there's another law in Pennsylvania known as the Statutory Construction Act, which defines what words mean. And because that word may is in there, it also means may not. So as an agency, you could adopt a provision that says we will only accept right to know requests where the person is identifying themselves. We will not accept anonymous requests. Okay. And that's just one quick example of, where you have the flexibility to establish your own local provisions. As long as it's not in conflict with the law or any provisions mandated by the Office of Open Records, you should be fine. You can come up with your own form. Most agencies do. They like to have their seal at the top, contact information for their arrow, maybe some of those local provisions so people know what the playing field looks like. And then finally, we ask that you let us know here at the Office of Open Records who your arrows are. We maintain a database on our website that's accessible to the public. It's searchable based on the municipality. But we realize, people move on, they get promoted, they retire, whatever. So it's important that we keep this database current. So maybe you want to take a look at that if you're an arrow. Make sure that your municipality is up to date. If it does need revision, there's a form there to fill out, email it to us. We'll verify it and then update the database accordingly. But, thanks in advance for doing that for us. You must have postings in both physically within your office as well as on your website if you happen to have a website. And use these postings as an opportunity to educate the requester. Okay, that's my mantra here this morning. The more information that a requester has about what the process looks like and what they should expect, the easier the transaction is going to be for the requester and for the agency. Okay, everybody's on the same field, on the same page, and pardon my multiple use of metaphors here, but that's how you make this system work. Okay, so the postings, you need to have the contact information for the arrow. Remember what I said. Who do I give this request to? Contact information for the applicable appeals office. Now, in almost all cases, the appeal is going to come to the Office of Open Records. So what I recommend is just include the URL for our website because they can file appeals online on the website. And then include a form in case they don't have one, so that they can either download it from your website or have it available there in your office, that if you require that they fill out a form for a right to know request, you can provide a blank to them. And then also finally list any of those local policies that you may have promulgated. Okay, questions popped up. Can you appoint an assistant or backup open records officer? Why, yes, you certainly can, and we recommend that, okay? And some municipalities are small. They only have one person wearing many hats. There's no one available to be a backup. But, if you have the staff to do it, please do so, because that way when the open records officer is out of the office on vacation or out sick or whatever, there's someone available for them to step in and, at the very least, keep the process rolling. So yeah, you can do that, and we strongly recommend that you do that if you have the resources to do so. Okay, what can't you do under the right to know law? Well, first offhand, you can't limit the number of requests or number of records that a person requests within a specific time frame. You can't say, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. She can file as many as she wants. Also, you cannot deny a request based on the reason or what you think the reason might be. And, sometimes, the reason is that people just want to see you work harder. All I'll say at this point is that if you're having a problem with a frequent flyer or a problem requester or whatever, I have found through my experience that the solution usually lies in the payment side of the right to know law. Okay, and we actually offer a webinar on payment issues in the right to know law that I would recommend you take a look at. If you have a problem requester, usually the solution lies on that side. If you're attending today and you are a problem requester, well, shame on you. Please stop. And if you have a problem with the municipality, you should try and work it out in an adult fashion, and don't try to weaponize the right to know law, because it could come back to bite you. All right, so moving on. I like to define or describe the right to know process as an obstacle course. And looking at this course, well, you have the starting line, which involves receiving a request. You have a time standard, and I don't know if you're familiar with this or not, but usually at higher level events, not anyone can just enter the course. Rather, you have to have a previous history of, being competitive at that level. I kind of compare this to the deadlines that are built into the right to know law and the process. Then on the course itself, you have two hurdles. And in front of the second hurdle, we have three hoops that we have to jump through before we can even get to the hurdle. So using this as an outline, let's talk about the right to know process in the context of an obstacle course. Okay, receiving a request. What do you have to do? Well, first offhand, you note the date that you receive a written request, either with a timestamp or just write in the date or whatever. This is important because there's a clock that starts ticking when the open records officer receives a right to know request. And it's basically you have 5 of your business days to provide an initial response. Okay, so what does that mean, 5 of your business days? Well, if you're a Monday through Friday operation, it's pretty straightforward. But let's say you're closed for a holiday. Well, a holiday is not a business day, so you would add another day. Or let's say you close for an emergency weather situation. You get dumped on with a bunch of snow or something like that, and the administrative offices are closed. Well, that's not a business day. And obviously Saturday and Sunday are not business days. You take a look at what days is your operation open for public access, on the administrative side. Now, police departments, 24/7 operation, but the administrative offices aren't open 24/7. They're usually only open, Monday through Friday operation or less, whatever. If you happen to be a small municipality and you're not on a Monday through Friday schedule, let's say you're only open 2 days a week. Hypothetically, your 5 business days are Monday, Tuesday, then you go to week 2, Monday, Tuesday, then you go to week 3, Monday. That would be your 5 business days, which is, the deadline that you have to provide an initial response. Also, you want to maintain a copy of all the paperwork, okay? Don't just toss it. Even if you think you've granted the request and everything's fine, that may not be the case from the requester's perspective. So under the right to know law, the provisions are that you maintain everything for 30 days or until all appeals have been exhausted. And if there is an appeal, chances are you'll know about it, but it could go all the way up to the Pennsylvania Supreme Court, so it could take years. So hang on to that paperwork. There is another law in Pennsylvania. It's called the Pennsylvania Municipal Records Act, administered by the Pennsylvania Historical Museum Commission. Within that law, it says you should hold on to everything for a minimum of 2 years. I like that, okay? Now the Municipal Records Act governs all records that a municipality usually has possession of. But I kind of like the idea that if it's a right to know material, hold on to it for 2 years, just in case you need to refer back to it for, any number of things, reporting, maybe a question comes up, whatever. Okay, I just think that's a good practice. So hang on to stuff for 2 years. After 2 years, get rid of it. If there's no appeals pending, shred it, recycle it, throw it out, whatever, because you don't need it any longer. And, we have too much paper already. So after 2 years, have at it, have fun, just, put it in a burn barrel. Well, you can't burn right now because the state's under most municipalities are under a burn ban, but get rid of that paperwork. Okay, let's say you can't provide your initial response within the 5 business day deadline, the right to know law allows you to take a 30 calendar day extension. Okay, note the difference, calendar days versus business days. So you just pull out your calendar, count 30 days. Now, there are some conditions, though, in order for the extension to be valid. First offhand, you have to take the extension within the initial 5 business day window. You can't wait into, for whatever or to what otherwise, yeah, they pay me to talk, with what otherwise would be the 6th business day and say, oh, look, I forgot about this right to know request. Well, we'll just take an extension. Because you missed that 5 business day deadline, you've denied it by default. Legally, it's what we call a deemed denial. Okay. Next condition is that you have to notify the requester in writing that you're taking the extension. And if they submitted the right to know request using email, you can respond back by email. Then you need to provide a reason. Why are you taking the extension? And if you go to section 902 of the law, they actually list 6 reasons that you can pick and choose the most appropriate one. It could be we keep these records off site and it's going to take us longer than 5 days to go find them and go through them. Or it could be we want our solicitor to review the response to make sure we're not giving out anything we're not supposed to. Okay. Then you need to provide a date as to when the requester can expect to get a response. And usually that's on the 30th day of the extension. And then an estimate of any costs they can expect to accrue. And it's just an estimate. It's not a hard quote. You settle up on the exact amount when you provide the actual records. So you've got your 5 business days and then the 30 calendar days tacked onto it. Now, don't get into the habit of automatically invoking the 30 calendar day extension if you don't need to, okay? If the records that are being requested are clearly public, they're readily available, okay, go ahead and respond and let the person know the status of their request. But at the same time, I realize that many municipalities have limited bench strength. You need that 30 days because you've got so many other job responsibilities to take care of. Okay, that's okay, that's valid. But look at this from the public's perspective. Okay, something important has come up. They need a public record. And then the first communication they get back from the municipality is, oh, we're taking another 30 days. Okay. Especially if you don't need to, that just upsets people. Okay. And you don't need that. You don't need that headache. Okay. So only invoke the extension if you truly have a need for doing so. Okay. So we are now up to the first hurdle. In order to make it over this hurdle, we need to answer a question. Is it a record? Okay, now that seems rather obvious, doesn't it? But I tell people when you're trying to understand a law, a lot of times you encounter vague language, it's written in legalese, or there's what appears to be conflicting language. Always go to the definition section and it will help you, usually, it will help you understand what the law is actually saying. The right to know law is no different. It's not a big law. It's, for the most part, written in common English, but there is a definition section that helps you out. And sure enough, in there, there's a definition of a record. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase in red, documents a transaction or activity of an agency. What does that mean? Well, a record reflects the mission and duties of that particular municipality or state agency. Okay. Now you're thinking, well, why would we have a record or why would we have any sort of communication that doesn't reflect a transaction or activity of the agency? Well, think about it. Let's say I send an email to one of my colleagues. Hey, did you hear about the new restaurant that's opened up downtown? Let's meet for lunch tomorrow. Or I send a text message to one of my coworkers. Did you see the trades that the Eagles are making? What do you think that's going to do, for their chances this coming season? Or, something as arcane as I'm picking up a pizza on the way home tonight, hon. All right. all fairly common communications that do not reflect a transaction or activity of an agency. Okay, so the result is, under the right to know law, those communications do not rise to the definition of a record. So they're off the course. They don't make it over the first hurdle. So as an employee, I don't have to worry about those arcane communications being released through the right to know law because they're not considered records. All right. Only those communications that reflect the mission and daily operations of the municipality rise to the level of a record. Okay, so that's the first standard. Now, let me turn this around a little bit after I get a sip of coffee. Let's say I'm at home, I'm a public employee or a public official, but I'm at home in my family room. I'm on my personal computer. I'm on my personal Gmail account. And I send out a communication to my, fellow elected officials on the board. And it involves borough business. Okay. The fact that I'm at home on my personal computer, on my personal Gmail account, has no bearing on whether or not it's a record. Okay. It all comes back to the content of the message. Does it reflect or does it document a transaction or activity of the agency? And that would apply to my personal computer, my laptop, maybe my personal cell phone that I'm using to conduct work or agency business on. It comes down to the content of the message, not how the message was created, or how it was sent, or where it's stored, or anything like that. Okay, does it reflect a transaction or activity of the agency? That's determinative as to whether it qualifies as a record and whether or not it makes it over the first hurdle. Okay, moving on, we come up to the second hurdle, where now we have to answer the question, is it a public record? Note the distinction. First, is it a record? Now we have to answer, is it a public record? But remember, we have 3 hoops that we have to get through before that question is answered. The first hoop, we have to answer the question, are there any exemptions that apply? And if so, are we going to invoke them? Okay, what the heck is an exemption? Well, within the right to know law, we go to section 708B, and there are 30 exemptions. An exemption is a paragraph that describes types of records that the agency can withhold if they want to. And honestly, download the law from our website, take a look at it, go to section 708. And when you read this, number one, it covers an incredible scope or variety of records. And number two, every one of those exemptions, when you read it, it's like, well, yeah, these records should be confidential. We wouldn't give these out. Okay, for instance, one of the provisions says that you can withhold a record because if by releasing it, it would put someone in physical danger. Makes sense. Okay. There's others that say, for instance, employee health records. You wouldn't release those to the public. Any record that would provide information about a minor, to a degree, educational records or any discipline records. Okay. All stuff that someone has a right to privacy concerning. So therefore, the exemption allows the agency to withhold them. And note that I'm saying it allows them. It doesn't mandate, because remember, the right to know law is not a confidentiality law. You're not going to find anything in the right to know law that says you must withhold these records. Rather, the right to know law says you can withhold these records, which also means that the agency, at its discretion, can release certain records, even though they're clearly covered by an exemption, which is why we have the language in there. Are we going to invoke them? If you choose not to invoke the exemption, the agency has the discretion to release them. Okay, and then there's a big but at the end of that sentence, which I'm going to talk about here in a moment. after I read this question. Once someone has received their right to know, are they legally allowed to post it on social media? Okay, I am assuming, Ms. Cunningham, that you're saying that if you receive a response to a right to know request that includes the records you have requested, the answer to your question is absolutely. You're receiving the records because they're public. So what you do with those records is your business. So if you want to put them on your Facebook page, or maybe you have a website, there's absolutely nothing wrong with doing that. And there's many people that do that, whether it be for good intentions or not. You know, it is amusing sometimes to go out on Facebook and find the Facebook pages that some people have created as watchdogs. You know, some of them are very good. And they actually, I think, help the community. And it's not adversarial. Rather, it is a supplement to the information that the municipality is putting out. And, you know, it allows the public to comment, which I think is a useful tool for public officials. And then you run into some others where it's obvious people have an agenda. And, you know, they'll use the right to know to get records, and then they'll slant it in a certain way, you know, and that's just part of living in a democratic society where we have free speech. It happens. Okay, but yes, pardon my long-winded answer, but the short answer to your question is absolutely have at it. Okay, they're public records. All right, back to the slide here. Now we're at the second hoop, and we have to answer the question, are there any federal or state statutes or a judge's order that make the records non-public? And this provision, you can read it in Section 306 of the Right to Know law. Now, in addition to the Right to Know law, depending on the nature of the record, there may be other laws that govern whether or not that record is public. First, if that's the case, that law and its confidentiality provisions trump the Right to Know law. And there's language, like I said, Section 306 of the law that validate that. Okay, if there is another law that makes a record confidential, that law trumps the Right to Know law. A couple quick examples: health records. Okay, now there is language in the Right to Know law that allows an agency to withhold employee health records. Okay, but remember, under the Right to Know law, you have the discretion to release those records if you want to. But there is a whole alphabet soup of federal statutes that make it illegal to release employee health records. And it could be, you know, HIPAA, ADA, FMLA, and a host of others that you simply do not release these records under penalty of, you know, some sort of sanctions. And it could be criminal in nature. Okay, so that would trump the discretion that's allowed in the Right to Know law. You cannot release employee health records because of the federal statutes. Another example, in Pennsylvania, there's a law called CRIA, the Criminal History Records Information Act. Okay, under the Right to Know law, there's nothing, while there's a provision for criminal investigatory records, there's nothing for criminal intelligence records. Okay, and let's say that a municipality is keeping track of suspected gang activity, okay, criminal intelligence. Someone submits a Right to Know request for a copy of these files. Well, there's nothing in the Right to Know law that would prevent giving those out. But under CRIA, the Criminal History Records Information Act, police departments are mandated to withhold criminal intelligence information. They can only share it with other police departments. Okay, they cannot give it out to the public. So you understand how that works. So let's say then the response to the Right to Know request, because remember, agencies bear the legal burden, they would then refer to the appropriate confidentiality provisions in CRIA as the basis for withholding the records from public access. Okay, and then we come to the third hoop which is what I talked about earlier when we had the question about attorney invoices. And that is the record protected by privilege? And here we go back to the situation of the solicitor providing legal guidance and advice to the elected officials, to senior management of the municipality or the authority or the agency or whatever. Okay, that communication, whether it be emails or letters or memos or whatever, okay, is protected by attorney-client privilege. And we would go to Section 305 of the Right to Know law to find the appropriate reference that if a record is protected by attorney-client privilege, the agency can withhold it. And when you take a look at a privilege, which is defined under the Pennsylvania Rules of Evidence, you'll find that legally the agency is not allowed to release these records. Okay, again, there is a provision that says you may not release records protected by attorney-client privilege. And again, there are sanctions for doing so. Okay, so let's say that we get our right to know request and we take a look at all of these provisions. It is a record. There are no exemptions that apply here. There are no other laws that say it's confidential, and it's not protected by attorney-client privilege. Once we've made it through all these obstacles, at that point, can we jump over the second and final hurdle? And then we're saying it is a public record and it gets released into the public domain. Okay. Now, we're going to release these records. So depending on the situation, we may be able to charge a fee. Commonly misunderstood provision of the right to know law is that people think it's free. It's not. You can assess a fee if it's appropriate. Okay. So a couple issues here that I want to cover real quickly. And two things I should mention. Going back to the other laws, we actually have a webinar on confidentiality laws, and these would be a listing of other laws that we typically encounter that have confidentiality provisions that mandate that you withhold records. You might want to sit in on that webinar. And also, we have another webinar strictly dealing with payment issues and the right to know law, where we spend a whole hour going into greater detail on this particular topic. But some things you should need to know. First offhand, the agency is only required to provide the record in its current medium, okay? And this is covered in Section 701. What does this mean? Well, it's hard copy versus electronic, okay? Scenario. Let's say that we have a process that's entirely paper-driven, building permits, okay? Everything is done through the mail and permits and gathering information, et cetera, et cetera. When we're done, we put everything in a file folder, stick it in a file cabinet. So we get a right to know request sent in by email, okay? And the person is saying, I'd like a copy of the file on this particular building permit, and I'd like it sent to me electronically. And why do they do that? Well, for two reasons. Number one, it's easy. And number two, they think it's free, okay? There's no charge for electronic records. But if all the records are hard copy and there's no electronic version of it, the agency is not required to scan them in, okay? Because that would be converting them from hard copy medium to electronic, okay? You're not required to scan in documents if you don't already have an electronic version. What you can do is basically say, we have those records, but they're hard copy and it's going to cost you. Are you willing to pay? And if they are, well, then you make your copies and you send them to them. If not, well, then you consider the request withdrawn. Now, if you do have electronic records and they're requesting them electronically, well, then you send them to them and there's no charge for electronic records, like I said. There's a provision in the right to know law that allows for something called inspection, okay? You can ask for copies or you can ask to inspect the records, okay? And inspections means I'm coming into the office and I want to review the original documents. All right. Well, the agency goes through the same exercise. Are these public records? And if they are, yeah, we're granting access for your inspection. But the agency is in the driver's seat. Okay. They determine when, during normal work hours, it's convenient for you to come in and review the file. And they can supervise the inspection. They can sit there and watch, make sure nothing is destroyed, altered, or stolen. Okay. And if you want to pull out a cell phone camera and take a picture of the records as you're inspecting them, you can do that because they're public records. Okay. They're allowing you to review them. Okay. Agencies cannot charge for labor. You can't charge for redacting, which is where you're blacking out certain information. And you can't charge for any sort of legal review. These are all just considered the costs of doing government business. You can only charge for actual costs, like postage or making large copies if you have to run down to Kinko's or Staples or something like that because of what's being requested. All right, I've kind of hinted at this or, stated it more emphatically throughout the presentation, but no surprises. Let people know what to expect when they submit a right to know request, and that includes expenses. There's absolutely nothing in the right to know law that prevents you from picking up the phone and saying, I looked at your right to know request. I think, when it's all said and done, it's going to cost you about $30. Are you okay with that? Okay. And they're going to say, why? Well, no, I thought this was all free and I'm just going to withdraw my request. Or they're going to say, yeah, that sounds reasonable. I'm willing to pay the $30. And then you begin processing. Okay. Communication is good. If the right to know request isn't quite as clear as you think it should be, maybe you're not absolutely sure what the person's asking for, pick up the phone or send an email and ask the question, is this what you mean here? Just so I understand. Okay. Have that conversation and solve any problems before they flare up into major wildfires. Okay. Now, the right to know law, and I'm paraphrasing here, basically says that records are provided upon payment. That means that the person pays first and then they get the records. Now, best mutual exchange, but if push comes to shove, you can demand payment first and you can wait for that payment to clear. So let me make a point here that, again, common misunderstanding. The deadlines built into the right to know law refer to when the agency is obligated to provide an initial response or a final response. They do not dictate when the agency provides the actual records. Okay. The deadlines, let me repeat this, refer to a response. The deadlines do not refer to when we provide the actual records. Let me get a sip of coffee again. Okay, so I can receive a right to know request. I can run through my exercise and determine, yes, these are public records. So my response within the appropriate deadlines is I'm granting your request and will provide you with the records when you send me payment and your check clears. Okay, perfectly valid. And then within a reasonable period of time, I realize that's subjective, but usually we're talking a couple days here. We'll send you the records or we'll give you access to the records. Now, if it's all electronic, it's going to be, practically instantaneous. We're granting your request. Here are the records and we're sending them to you. Okay, because there's no payment involved. But if there is a payment, you can wait for the check to arrive and you can process it through the bank to make sure it's good. Okay, and then you provide the records within a reasonable period of time. But let's say that you get a right to know request, you do a quick look at the size of the response and you realize this is going to exceed $100. Okay. This provision of the right to know law allows you to demand payment before you begin processing the actual request. I like to refer to it as a security deposit. And I think the intent of the right to know law is to prevent the agency from getting stiffed on a really big response okay, because now you have a check in hand. And again, it's an estimated cost exceeding $100. It's not the exact amount. You settle up a little more, a little less when it comes time to provide the actual records. Okay, but this provision is in there to help the agency by demanding the security deposit before you begin processing really big requests. Okay, and then we have a thing in here called, and I realize this is all over the map here, and this isn't encountered that much anymore, but Section 905 basically says that if someone submits a right to know request and you process it, and let's say that there are hard copy records, you let them know that they're available and they say, okay, I'm going to come pick them up. That and they never do, okay, the agency is obligated to hold on to everything for 60 days. After 60 calendar days, you can then discard the records. The thing is, though, that there was probably a cost in generating those records. That cost does not go away once you discard the records after 60 days. So if the person shows up like on the 61st day, well, they're kind of out of luck, okay, because the records have been discarded. The agency did everything it was obligated to do. And the cost of those records, let's say it's $30, that's still out there. And that does not go away. There's no statute of limitations on that. So until that person settles the debt for those records that they failed to pick up, the agency is not obligated to process any further right to know requests because of that outstanding non-payment. Okay, and it could be a request for the same records. It could be a request for entirely different records. Okay, so let me repeat this. If there is an outstanding debt from the requester, the agency can deny any further requests until that debt is settled. Now, the agency needs to make sure that all their I's are dotted and their T's are crossed. All communication is documented, the fees were calculated correctly, et cetera, et cetera. Because if you deny a request for non-payment of a previous request, that can be appealed. And the appeals officer will want to see all of the records or all of the communication that led to the decision to deny access to determine whether the agency was appropriate in doing so. And I'll just tell you as an aside, probably in about 90% of the cases, the agency is correct and the appeals officer verifies that, yes, the denial is appropriate. There's an outstanding debt and the person needs to settle up. Okay. All right. Moving forward, denying access, let's say that it didn't make it through the obstacle course, so you have to issue a denial letter. There's a format that should be used. Oh, question has popped up. Are these debts for right to know request fees only? Only for right to know, okay? If there's an outstanding debt for a water bill, they can still submit a right to know request and vice versa, okay? And the right to know law does not address any sort of collection activities, okay? But if there's an outstanding debt, you're good to go. Okay, denial letters. Well, first you just include a description of the records that were requested. Okay, and you're thinking, well, that seems rather obvious, but sometimes it's not exactly clear what people are asking for. Then the legal and factual grounds for the denial. This is where the rubber hits the road in the agency meeting its legal obligation to show why the records are not public. Okay, maybe you're referring to an exemption. Maybe you're referring to another law. Maybe you're raising attorney-client privilege, but you have to make that connection between the records that are requested and the legal provisions that you are basing your denial on, okay? And then you have the contact information for the ARRO. Remember, this is the person legally responsible for the response. It's also the person that the OOR reaches out to if an appeal is filed. The date of the response, and this is important because now the appeal window opens up based on the date of the response, and then you need to outline the procedure for filing an appeal. And that happens to be that the person has 15 business days to file an appeal, usually with the Office of Open Records. Okay, there are some exceptions, but we're not going to talk about them here this morning. So the best way for a person to file an appeal is to go to the Office of Open Records website, okay? And they can file it online. That feeds right into our docketing system and everything works out. Now, when we get an appeal, we look for four things. We need a copy of the original request, the agency response, provided there was one. Remember, you got those deemed denials out there. And then there's some questions that the person has to answer that satisfies their legal obligations. When we docket an appeal, we send out notice to all the parties that we have an active appeal. Now, this is a legal process, so it becomes very important. When the agency receives this notice, and this is probably the most important piece of advice you'll receive here this morning, if you happen to be an agency open records officer, do not walk to your solicitor's office to inform them that you have received, or the municipality has received, an active right to know appeal, okay? In essence, a person is suing you, and there is a limited time, a limited window that the solicitor has to respond on the agency's behalf. Okay, if you fail to meet that deadline, there is the possibility that the agency could lose the case on a procedural issue. Also, if you as an agency open records officer attempt to respond to the appeal, like if you think it's something really obvious, okay, don't try to respond by yourself, okay, because is this appeal a state administrative court or standard civil court? Okay, detective, it's actually the Office of Open Records. We are the decision maker of record. And this raises an important point. The Supreme Court of Pennsylvania has identified the Office of Open Records as an independent quasi-judicial tribunal. For purposes of discussion, we are the court, okay? We are the decision maker. Now, you're ahead of me, I think, by one slide, but our decisions can be appealed. And if so, if you're a local agency, like, if you're a local police department, it would go to your county court of common pleas. If you happen to be with, like, say, the state police, it would go to the Pennsylvania Commonwealth Court. They would be the next level in the appeal process. And it could go all the way up to the Pennsylvania Supreme Court. Our cases do go up that high. But the appeal that I'm talking about right now is before the Office of Open Records, before an appeals officer. And we have, I think, 18 appeals officers on staff right now. Okay, so your solicitor would be the person responsible for representing the municipality before the Office of Open Records. So that's my piece of advice there. Moving on, the product of an appeal from our office is what's called a final determination. This is a legally binding written decision, a written legal order that would, confirm the denial, saying, yeah, the agency is appropriate in its denial, or it could overturn the agency and grant the request to the appellant, saying release the records, or maybe something in between. Now, like I said, our decisions can be appealed. The moving party has 30 days to go either to the County Court of Common Pleas if you're a local agency, or the Pennsylvania Commonwealth Court. Okay, and these decisions are available on our website in a searchable database. It's like in excess of 30,000 and counting. You can search on municipality, you can search on legal issue, you can simply put in a random text string. You could put in your name and see if your name ever popped up in one of our decisions. But you can also find them on the legal services like Lexis and Westlaw, or you can find them if you have the docket number, you can simply Google it. And it's amazing how many law firms and other resources out there have our decisions out there available on the internet. Okay. There is the option of mediation, which, sometimes you get the impression that the parties haven't really spoken to each other, that they're just kind of yelling at each other and not making very good headway. We have trained mediators on staff that if both parties want to attempt a mediation, you can do that. If they're not able to arrive at a solution, well, then you can, no harm, no foul. You just go back to the normal process. But mediation's available, and you might want to take a look at that option. Yeah, finally, like I said, our decisions can be appealed, and we are at the end of the presentation right on time here, which means while I'm waiting for any final questions that you might have, I want to direct you to our website, okay? If you've ever participated in one of these webinars before, you know what I'm about to say. This is the best government website you'll ever encounter. Okay, it is updated 6 days a week with new information, new decisions issued by our office, maybe court rulings, um, notices about training opportunities, and the like. There are guides for citizens, guides for agencies. There is a guide for agency open records officers, 78 pages that you can download for free, and all kinds of useful information that you can use there. Okay, Rob Azonia. Oh, here we go. As per the fire company determination that was recently done for Right to Know, can you explain that a bit, please? Yes, that decision doesn't really change anything as far as the Office of Open Records is concerned. The question is, are volunteer fire companies subject to the Right to Know law? The answer from the court has been and was affirmed in this new decision. It depends. And that really depends on the level of control that is exercised by the municipality over the volunteer fire company. Now, you might say, well, we receive funding from the municipality. That may not be enough. Okay, what the courts have done is basically provide us with a list of factors that the appeals officers will go through and will ask the parties to comment on. And it involves such things as, is there a board of directors, and how's that appointed? Can the municipality hire and fire the fire chief? What is the funding stream for the volunteer fire company? What percentage of funds come through the municipality? Is there a contract for the provision of fire services for this particular fire company, et cetera, et cetera? Okay, so there's this laundry list of items that we ask for information from the volunteer fire company as well as from the municipality, that the appeals officer will then go back and take a look at. And in certain cases, yes, it's determined that there is a level of control or sufficient level of control issued by the municipality over the volunteer fire company to determine that, in fact, the volunteer fire company is subject to Right to Know. If, however, the volunteer fire company is fairly independent in its operations, funding streams, et cetera, then we may determine that no, the volunteer fire company is not subject to the Right to Know law. There is no black and white answer, unfortunately, at this time. And this really has been the case, I think, for about 2 years now. But just recently, there was a Commonwealth Court decision, unpublished, by the way, that more or less affirmed what our current practices are. We're still taking a look at the language that was in the decision itself, because there are always little nuances and stuff that we pick up on. But at face value at this point, we don't think anything's changed. And if we receive an appeal concerning a volunteer fire company, we're going to go through the same process that we have been for the last couple of years. Good question, very timely. And I appreciate it. It turns out I was at the Boroughs Association annual conference yesterday. Same question came up, same answer, but thank you. Okay, not seeing any other questions. I think we're at the end of the presentation. If you do have further questions, use our website, send us an email, call into the office. We'll be glad to help you out. But really good questions today. I want to thank you for your participation. We'll be back next week, okay? Usually we take a 2-week break, but because of vacation schedules and everything, I'm going to be back next week with another webinar Wednesday at 10 a.m. Look forward to seeing you if you're available. Okay, take care, folks, and thank you very much.